afternoon, and welcome to our March Easter edition of the Baylor LLM Roundtable. As a special series of Easter eggs for you today, we have got two leading experts on the new Federal Rule of Evidence 702, Quentin Brogdon, who is well known for his work on the plaintiff side of the bar, and Eric Lasker, who is well known both nationally and internationally for representing defendants in high risk, high stakes litigation. So gentlemen, welcome, and we can't wait to hear your thoughts and insights on Rule 702.
Thank you, Liz.
Eric,
Here.
I'm going to start with you.
Sure.
Because you were the instigator in many ways of this rule change with your article back from 2015. So if you would, for those of our viewers who haven't had a chance to really delve into the rule, give us a little background and what this rule change means.
Sure. And I think the history really is important in understanding how to understand what the Rules Committee did. Back in the early 2010s, there were a series of sort of high-profile cases in federal circuit courts that interpreted Rule 702 in ways that I and other members of the defense bar thought were not proper under the rule. And it led me to write a law review article that Liz mentioned, calling on the Rules Committee to take a look at Rule 702, look at how the rule was applied, and determine whether or not an amendment was necessary. And one of the key things that we discovered, and my co-author is a professor at George Washington University, David Bernstein, was that the Rules Committee had amended Rule 702 back in the year 2000, 7 years after Daubert, and they had set forth their understanding of what the requirements under the new rule would be. And when we looked at the case law, it was very clear that there were a lot of, at least clear to us, there were a lot of courts that were not applying the rule as intended. We went through that in our article. The Rules Committee then took its own analysis and looked at those same cases and other cases and reached the same conclusion, which was that there's a large body of case law out there where courts were not properly applying Rule 702. That is what led the Rules Committee to make the amendments, make the decisions it did to amend the rule. And it results in something that, without that background, can be a little confusing, because on the one hand, if you look at the advisory committee note, you'll see that the committee states that the amendments are seeking to clarify the rule as opposed to a wholesale rewriting of the rule, which, you know, if you just read that, it's not clear why then would the Rules Committee be taking that step, or how significant is this. But what makes this, in my view, and a lot of people's views, a very significant development is what the advisory committee also stated in its advisory committee notes and in its deliberations, which is that they were compelled to make this change because there's a lot of case law out there that is incorrect, was not applying the rule correctly. And if you are relying upon that case law, that's no longer good law following the amendment to Rule 702, and you really have to start over based upon the language of the amended rule, and courts have to start over to understand what their gatekeeping responsibility is. So that, in a nutshell, history.
Yeah, I want to get into in a minute what this new sort of four-pronged thing will be. But Quentin, you know, this was clearly an initiative that started with the defense side. What's the reaction, in your view, from the plaintiff's bar? Is this a worrisome change, or what's the view, since, you know, traditionally anything that comes from one side of the bar tends to make the other side a little twitchy? What are your thoughts about what the Rules Committee has done with Rule 702?
Well, Liz, they say even paranoid people have enemies. The plaintiff's side of the bar was very concerned, and I think that was articulated both in some law review articles and journal articles that were authored, in some of the positions taken by some of the plaintiff's side associations, and by the over 500 comments that were initially made in response to the preliminary draft of the rule. And the preliminary draft of the rule used the concerning phrase, at least in the eyes of some, preponderance of the evidence for the burden of proof that this showing to get your experts in would be required. And the concern from the plaintiff's bar, primarily, but not simply from the plaintiff's bar, was that this, in essence, was a comment that indicated we're taking away this from the jury to consider these things on weight of something, and we're giving all of that to the judge, as opposed to simply the admissibility finding. And for, that was one of the concerns raised in many of the comments. In response to those concerns, and I think this is a good sign, a change was made, a significant change that basically says, instead of the word preponderance of the evidence, it is now the language and the phraseology is more likely than not. The committee note makes clear, explaining the amendment, that in essence is preponderance of the evidence, but the intent apparently was to address concerns primarily on the plaintiff's bar, that somehow was changing longstanding law and formalities as to how these preliminary rulings were made by courts and under what standard. Now, as I said, even paranoid people have enemies. This gun kicks as hard as it shoots. I'm involved in cases all day long where defendants are putting forth experts who cannot and should not be allowed to ever darken the door of a courtroom. And so what is good for the goose is good for the gander. What is good for the plaintiff side is now good for the defense side as well. And this tool, and it is a tool, can now be used without respect to side of the docket. Many of the lawyers who were opining and weighing in on this represent both sides of the docket. I think that's important in commercial cases, because in commercial cases, you're not always plaintiff and you're not always defendant. But in the personal injury world, we tend to be more stratified and walled off in our respective camps. So I think, and then the committee note, I won't go into that yet, but at some point I could talk to you, Liz, and to the group about some of the comments in the committee note that should give comfort to those of us on the plaintiff side who are concerned about what this might be interpreted to be doing. It doesn't do everything. Some might want to argue it does. It doesn't change everything. Some might want to argue it changes. And the committee note makes that clear. It does change and clarify things, but it's not a wholesale revision as some might want to argue.
Gentlemen, do you agree? We're still looking at a traditional Rule 104 admissibility analysis. This change is just clarifying what became a hodgepodge of confusing case law that was at odds with the rule, so that it's really a clarification of how the courts will apply 104 for admissibility. Is that a fair summary of what y'all think the intent is?
Well, again, and it sort of circles back to the point I was making earlier, which is I don't know that there was a hodgepodge of decisions. What happened following the Daubert decision in 1993 was that there was language in that opinion that was grabbed at by both sides. I mean, there's just excerpts from that opinion that talk about more rigorous scientific evidence, and then there's also liberalization of the standards, and both sides were grabbing language from that and trying to spin the decision in one direction or the other. In 2000, when the Rules Committee amended the rule, and the rule since 2000 has been dramatically different than the rule that the Supreme Court was interpreting in Daubert, they were deciding between two paths. Is it a liberalization of admissibility, or is it a stringent requirements for gatekeeping? And the amendment in 2000 was intended to answer that question and say that it's more rigorous and you have to go through this structured approach. Unfortunately, that same dichotomy continued. So what we have with the new amendment is a express rejection, and they say it I think four different times in the advisory committee note, of cases that had viewed the standard in a more liberal way. And all of that case law, I would submit, is no longer good law following the amendment. So for some courts, it won't make a difference. There are some courts who are doing it correctly. But for a significant portion of the case law that, from our perspective, has been cited to us by plaintiff's side of the bar, those cases have been overturned by the amendment, and that is significant. Practitioners can't just go back to the same old cases, cite the language, and say that's governing, because there's a new law.
So what does that new law look like? What do you think this is going to look like going forward? And what do you see as some of the strategic implications of this amended, clarified Rule 702?
I don't think the amendment makes a wholesale change. I think most of us were assuming, when we were proponents of experts, that we needed to show the judge in a pretrial hearing, if challenged, by a preponderance of the evidence, that our opinions of the expert were reliable, the methodology was sound, et cetera, et cetera. And I don't think it changes that. Most of us were already operating under that assumption, and most judges, in my experience, were already applying the law in that way. Granted, we have reported decisions where the law was not applied that way. So to the extent this is just clarifying and bringing errant courts into line, then that's fine. But I do think we need to be clear about what the amendment does not do and did not do. For instance, in the note, the committee note to the amendment, it says that this amendment does not require a finding of reliability in the absence of an objection. So this is not self-executing. It's not necessarily self-executing. I think the court could have the sua sponte power to do that, but it's not a situation where automatically now every expert undergoes the scrutiny in the absence of an objection from the other side. And those objections should be, at least to some degree, self-policing. If you object to every expert in the other side's bevy of experts, you're going to lose probably some credibility with the court, unless truly those experts all are subject to being challenged, and rarely that's the case. Usually you need to be shooting with a rifle as opposed to shooting with a shotgun. Some challenges to expert testimony, the note admitted, will still raise matters only of weight and not admissibility. So we have not transitioned now, this is important to note, to a world in which every challenge of every expert necessarily relates to admissibility. It may indeed, and the note concedes this, still, even in this post-amendment world, relate only to weight as opposed to admissibility. And I think it's important to, a couple of other things the committee note said that should give comfort to proponents is, there's no requirement that the proponents show that, quote, the assessment of their experts are correct. They only have to demonstrate by a preponderance of the evidence that their opinions are reliable. So it's not a Mount Everest that cannot be scaled if you have a good expert and you're prepared to deal with and to show the judge by a preponderance that your expert is using reliable methodology. And
Well, and Cliff, let me ask you a question about that. So again, from your view, 702 will be looking less at ultimate conclusions and more to process of how you got there, you being the expert, and so we can differ about conclusions, we can cross-examine and challenge, but if the process used is reliable, then that should be admitted?
I think that's very well said, Liz. I think that hits the nail on the head. That's my view of what 702 does and does not do post-amendment.
Yeah, I
Well, let
think
me flip to Eric.
I think I actually agree with that. It may just be on how we view that playing out in litigation. I think one of the key things that the rule does, and first of all, one of the changes the committee also made sort of after comments was they added the language that the court must make these determinations. And as you mentioned, Liz, there are 4 requirements now, and there have been 4 requirements for some time, but courts were sort of missing that. Each of which, subparts A, B, C, and D, each of which the proponent of the evidence now has to establish for the court have been met by preponderance of the evidence. I think going forward, those 4 subparts and an analysis of each of those subparts are going to be much more of the focus, as opposed to sort of the language or loose language of cases. It's going to be following the steps that are set forth and the structured approach that's set forth in the rule. And that is going to, I think, provide a much more appropriate and also rigorous test for experts. And Quinn is exactly right. It's experts on both sides. And when you know, in civil cases and also in criminal cases where this was also a very important issue. But when you talk about what the process is, I would urge folks to look at subpart D, which is that the expert has faithfully applied the methodology or reliably applied the methodology that they are claiming to use. That has been in the past, and where a lot of courts have gone wrong is they've sort of punched on that last step. They've looked at the expert, determined they're qualified, they seem to be following a standard methodology, and then they've just said it's now for the jury to decide. And that no longer should happen.
So Eric, let's drill down on that a little bit, because subpart D used to say the expert has reliably applied the principles and methods of the facts of the case. And now it says the expert's opinion reflects a reliable application of the principles and methods.
Right.
Both of you talk a little bit more about how is that language different?
So I think this, I can start, Quinn. I think this deals with one of the parts of Daubert that creates some confusion. And the Supreme Court tried to clarify this in G versus Joyner, which is, do you look at conclusions or not in determining admissibility? In Daubert, they said no, and then in Joyner, they say, well, yes, if the conclusion is too far of a leap from the facts that the expert's applying. And so the import of that change, I think, is that, for example, I'll give you an issue that arises in the cases that I handle in my firm, Hollingsworth LLP handles, which is toxic tort cases where you have issues of causation. In those cases, you'll often have experts on both sides claim they're using the same methodology. There's a methodology called Bradford Hill that is a methodology of determining causation of an exposure and a disease. And there would be, what plaintiffs' experts would do is they'd say, we are using Bradford Hill, it's an accepted methodology, and it's the same methodology the plaintiffs' experts are using. And some courts that were not properly following the rule would say, well, that's enough. But now, and there was a recent opinion in Ray and Glinza that after the amendment that did this, courts will say, well, you say you're using Bradford Hill, but let's see if your conclusion actually follows faithfully from applying that methodology. And so you have to actually look at what the expert has done and look at whether or not their conclusion actually follows a faithful application of that methodology. And that's for some courts, that's a fundamental change in the way they look at admissibility.
Liz, the change to that 4th prong that we're now discussing, 702D, to now require that the expert's opinion reflects a reliable application of principles and methods to the fact of the case. In the committee note, the committee raises a concern specifically and particularly about so-called forensic experts, and the idea that courts, at least by implication in the note, are not doing enough to root out opinions that are purely subjective and or opinions for which there's been no evidence considered by the court as to the potential rate of error for that methodology for the opinion. So one of the things the committee note tellingly says in describing the need for and the rationale for this change to this 4th prong is the following. It says, the judge should, where possible, receive an estimate of the known or potential rate of error of the methodology employed, based, where appropriate, on studies that reflect how often the method produces accurate results. So that is a marker that's been laid down within the committee note, at least, for those of us both presenting and defending and proffering experts and those of us attacking experts, that there will need to be, there should be, in the wake of this committee note, some evidence. You better darn well go find it about potential rate of error of the methodology employed.
Hey, but here's a question that I know one of my colleagues, Cal Dreyer, wanted to ask. Does that unfairly hamper litigants in cases where we have a long lead up? We have, and I'm trying not to use any specific case, but we have a claimed toxic exposure and we've got these people and we're starting to get this general causation evidence, but we don't yet have robust data. Does 702 say, well, too bad, you should, go do more studies? How are we going to handle that tension between injured persons who legitimately say, at least the preliminary evidence leads me to believe that this exposure was the cause of this injury? And how do you balance that with defendants who say, prove it? There's nothing. I mean, to me, that seems like a potential gap in this new application of the rule.
Well, I mean, I think that's an issue that has existed. And again, it's one of the issues I think that the Rules Committee had thought had been decided and courts had not, some courts had not. I think the case was In re Rosen out of the Seventh Circuit that had the quote, law lags science, it doesn't lead it. And that's also consistent with some language in the Daubert opinion itself. There could be things that in the future there's evidence showing, but until that evidence is existing, you don't know which way it's going to turn out. And so if the science isn't there, if there's not a reliable basis to establish causation, and an expert can't do that under the rules, then yes, that testimony is excluded. Parties, litigants have to prove the case based upon the existing evidence. And if that evidence doesn't exist, then they haven't established their burden. That isn't really different than any other case that you can imagine where people are trying to investigate a basis to support their claim and they think they've got it, but they don't quite have enough evidence. If you don't have enough evidence, you haven't proven your case.
I could pretend that language about the court receiving an estimate of the known or potential rate of error of the methodology does not have the potential to handicap plaintiffs in cases such as what you described, Liz, but I think that would be disingenuous. I think it absolutely does. There is some couching language. The judge should, and then parentheses, the note says, where possible, receive an estimate of the known or potential rate of error of the methodology. And then it says based, and then in parentheses, where appropriate, says the note, on studies that reflect how often the method produces accurate results. So there's some comforting language, but yes, interpreted literally, that could actually handicap plaintiffs in certain types of cases, such as what you described. Absolutely.
And I think, Quentin, that language or the caveats are dealing more with cases where you have like experts that are not providing opinions that have studies. I mean, this is something that the Supreme Court dealt with as well, as to what do you do with, when you're dealing with a toxic tort where there's epidemiology or there's toxicology, then you do have data. So it always depends upon the type of expert that you have. But in those types of fields where there is scientific studies and there are ways of testing methodologies, I think you're going to have that evidence to present, or your expert is, in order to be admissible.
Yeah, and I don't see that there's any change in what qualifies someone to be an expert such that they can testify in the form of an opinion. And so you still have education, training, experience, it isn't all epidemiology. The qualification part of 702, knowledge, skill, experience, training, or education, to my reading, is unchanged by that.
Yeah, that hasn't changed, but the 4 requirements are disjunctive. You have to prove each of the 4. So showing expertise satisfies subpart A, but you still have to satisfy subpart B, subpart C, and subpart D.
So Eric, let's talk about that. You've got a challenge to an expert and let's talk about what is sometimes our no evidence summary judgment standard in Texas. There is no evidence of proximate cause, and that flips it to the party who has the burden of proof to come up with legally sufficient evidence. So first of all, do you think it's fair game under 702 simply to challenge broadly that this expert doesn't meet the requirements of the revised rule? Or is that going to require the party challenging to hone in on the particular aspect that's at issue? I mean, just as an advocate, I would think a judge would take you more seriously if you can specify the ground, but what do you see these challenges looking like in terms of breadth?
I think a good attorney on both sides is going to need to focus on the subparts. Having general statements or general objections is not useful. You need to focus on the language of the rule and the language of the subparts and walk through. And, to Quentin's point, if you have a qualified expert, you shouldn't be challenging them under subpart A. You should skip over that and say, I'm not challenging expertise. If they're relying upon facts that are accepted facts, you're not challenging them under subpart B. You want to focus your challenge on where you believe that the expert has not met that, more likely than not standard. And then, then the court has the obligation to assess that.
I agree completely. And one of the issues I think you alluded to, Liz, was strategy and the whole timing issue. I think good attorneys on both sides will make darn certain the scheduling order in the case has deadlines for the assertion of these, rather than just leaving it to the vagary of the specific judge and or the sometimes ambiguous case law that seems to allow, in some reported cases, challenges very late in the day. And so you want to be sure to remove that ambiguity in your scheduling order. I think good lawyers have already been doing that, but I think, that will not change. I think you still need to do that.
Yeah, and there have been
Well,
there have been cases in the past where appellate courts have reversed because the trial court did not go through the process it needed to go through. Exactly like Quentin mentioned. And I think that trial judges now will need to be even more cognizant of that. They have this obligation to go through the requirements of the rule. They need to provide the time to do that, and they need to conduct the type of hearing that will allow them to do that. I think in more cases, you'll be seeing evidentiary hearings under Rule 702 than perhaps you were in the past, so that a judge, this is a part of why this rule hasn't been really followed by some courts, is it's a hard rule. You got judges now having to address scientific issues they're not comfortable with. But in order to do their job, they're going to need to understand that. So they may need to have evidentiary hearings. They may need more consideration, time to consider the challenge. And we'll be seeing more of that in the future.
that raises so many issues. I'm stumbling over all the questions I want to ask. Okay, so can you fairly have one of these 702 challenges evaluated by submission?
I would argue you can, but I know based on some conversations we had before, Eric's view may be somewhat different. Obviously, it's going to depend upon the expert, the methodology in question. And I think there's an argument to be made. I concede that if courts are fairly enforcing this rule, as it's now been clarified through the amendment, then there may indeed be more hearings with more testimony. And I think sometimes I've been in situations as the proponent of an expert where a court says, we will not take testimony from the expert. And I wanted there to be testimony because of the affidavit. So it cuts both ways. Sometimes you want to get this preliminarily thrown out if it's kind of a bogus challenge or a weak challenge. Other times you as the proponent want the live testimony. And I've been involved in some situations where judges would not allow it.
So is that something you want to have in the scheduling order? Do you want to try to politely, of course, as we do with federal judges, politely inquire as you're crafting the scheduling order, or to try to come in with agreement by the parties about whether these will or will not be evidentiary hearings? I That would certainly make a difference to me in the amount of questioning I did potentially of my own witness at a deposition. If I'm gonna have it by submission, I want a robust record.
Yeah, I think that it will work its way into a lot of scheduling orders, and I think there's reasons as Quentin mentioned, on both sides. I mean, first of all, you need to have a record that establishes that the trial court properly applied Rule 702. And as a plaintiff's counsel or as a defense counsel who's putting forth an expert who's been challenged, the idea that you can just sort of slide by and not have the court do this, well, then you've got an appellate problem, because the appellate court has to look back and see if the trial court has properly applied Rule 702. So I do think it's going to work its way into scheduling orders, and I think it's going to also focus the court's attention on the fact they've got to do this work. I think a lot of times courts don't want to do it. And this rule, adding the language, the court to the rule, and the fact that, there were so many courts that were doing this incorrectly in the past, is a message to trial courts that they need to up their game, or some of them do.
Eric's point about forcing the courts to do things, I think we as advocates have a real responsibility not to abuse this. I think if we indeed want courts to have meaningful hearings on legitimate challenges to experts, then we need not to abuse this gun we've been handed. We need not to be firing it at everyone on all occasions, because what happens from talking to my friends who wear black robes is soon it is ruined for all. If the judge perceives that in every case they're just throw down Dalbert challenges, then judges quickly say, okay, here's how we're going to do them. We're going to run them through the mill. I don't have time on my docket to sit and have all these half-day hearings in a case where somebody's filed. I have one right now where at least 15, maybe 20 have been filed. Literally every plaintiff's expert is being challenged by the other side. And I don't know what that judge is going to be thinking other than, oh my goodness, I need to set aside a bunch of time for these. So I think we, as members of the American Board of Trial Advocates, as members who preach civility, as litigants and lawyers who follow in Texas, the Texas Lawyers Creed, we just need to be diligent and careful about how we use this. Let's use it when it legitimately should be used, but let's not overuse it.
I think that
You remind me of the,
I agree with that.
yeah. Now you remind me of the judges who I've seen lawyers file 100 motions in limine, and I saw a judge look at him and said, I will hear your top 3. We're not going to pre-try this case for a week. We're going to get it done. And I think you do, to your point, undermine your credibility and abuse the court's good graces if you don't. So, we've talked a good bit about subpart D, but talk a little bit about the situations, subpart. We've talked about what makes a witness qualified, but being qualified generally does not necessarily mean that that qualification is helpful to the trier of fact. And that's subpart A of the rule, unchanged. But, when we talk about this conjunct of all 4 things, do you see situations where what the expert brings to the table doesn't actually help the trier of fact on an ultimate issue? Or is...
I mean, that has happened. There are experts that will go beyond the scope of their expertise and offer opinions that are sort of outside of their bailiwick. As you mentioned, the language of the rule for subpart A has not changed. To the extent there has been a change, it's that courts have to address this. They have to hold the whoever is putting forth that expert to the more likely than not preponderance of the evidence standard that expertise does fit the opinions that are being offered. So, that's first part of the change affects all 4 subparts. It requires a harder look by judges. It makes clear they have to take a hard look at that. And so to that extent, yeah, it's going to impact it.
Eric and I are in agreement on that.
Yeah. If the challenge is to subpart D, then do you see some opinions coming out of courts that say, subparts A, B, and C are not challenged or at issue, and so the court focuses its inquiry on subpart D. Do you think that gets them there if we're really looking pretty granularly at one aspect of a challenge?
Yeah, certainly there can be cases like that. I think what you've had in the past, and one of the things that the advisory committee points out, and not only in the note, but in a lot of the deliberative materials, and I've written a number of articles that sort of talk about some of the information in the briefing books that the advisory committee had, and it's another source of information as to what they had in mind. But there are courts out there and there are circuits that basically say, we don't get to subpart D. I mean, they don't say it that way, but they basically say, as long as they've got facts and they're following methodology, unless it is completely impossible, that's an issue for the jury. And those are the cases that are no longer good law, and can't be followed anymore. So yes, I do think there'll be cases where the courts can focus on a particular subpart, but what there shouldn't be anymore are cases in which courts are ignoring or rejecting the fact that each of the subparts has to be satisfied.
And I think it's clear, and I think Eric has raised this point a number of times, you have to show all four of those things. So if you show the first three and you don't show the fourth, based on the plain language of 702, the court can strike your expert just based on Part D. Specifically, the expert has, quote, reliably applied the principles and methods to the facts of the case. If you don't show that, the expert's opinion reflects a reliable application of, is the new language. If you don't show that, just that, you can be stopped at the gate by the gatekeeper, the judge.
Okay, let's get to what I think is one of the stickier aspects of how to do this. So when you are showing to the satisfaction of the court, more likely than not, from an evidentiary perspective, is that legal sufficiency? Is that factual sufficiency? Is that the same, more likely than not, that we're going to apply to the weight the jury gives it? I mean, what does that quantum of proof look like now when the judge is ruling on admissibility? I mean, how do you even argue the legal structure for that? Is legal sufficiency, factual sufficiency? What are we talking about?
Those were some of the concerns raised by the plaintiff's bar in the 500 plus comments that were made to the first iteration, an iteration of the rule for burden of proof that used the phraseology, the freighted phraseology, preponderance of the evidence. And the committee, based on the note, at least, adopted the softer language, more likely than not, in response to those. But that was the concern, that somehow there's been this shift from, that we're taking this away from the jury when it's in questions and in issues when it's a weight of the testimony as opposed to admissibility of the testimony issue. I know Eric will have some thoughts on this, but that's the way I read that.
Yes, I think it really, you have to focus on what the question is that's being asked. The judges under Rule 702 are being asked to answer 4 specific questions, the 4 subparts of the rule. None of those are questions that a jury is answering at trial. The trial, you don't have a jury verdict form that says, we the jury find that the expert has faithfully applied that their conclusions reflect a faithful application of their methodology. So it's not displacing the jury because there's different questions that are being asked. But for the 4 parts of the rules, subparts A, B, C, and D, the burden and what a court has to do is in some ways similar to what a jury has to do. It's just he's not answering the same question. He's answering threshold questions that the rules state need to be answered before you can actually get that expert testimony into evidence. So, as far as what is more likely than not, or the preponderance of the evidence standard mean, I think with respect to each individual question, it's pretty much the same thing. It's just there's different questions for a judge than there would be ultimately for a jury.
Eric, are there really? I mean, let's say the judge says it's admissible and you still think the expert is attackable.
Mhm.
on facts they didn't consider, assumptions they made, how they applied it, you're still gonna go after those same facts. You're not qualified. You're all book learning, no application. I mean, that's a huge part of cross-examination at trial, even if it gets over the threshold. So yes, there's not a blank on the jury verdict form, but aren't we still going to be attacking these? And isn't there still some inherent tension with the court making that decision and the jury using that to assess credibility?
So, I mean, that's at least the way the rule should work. Once the court has made the threshold determination, then you will fight out before a jury. And yes, you're right. A lot of those issues will be subject to cross-examination on both sides. But then, I mean, it's not, virtually every trial, there's experts on both sides. And then you have a jury having to decide which expert they believe. You can have experts on both sides that provide reliable opinions, and you still have to decide which one you believe in. So yes, the cross-examination will still be, a lot of the cross-examination will still be the same, but the cross-examination you do in front of a jury is not the same cross-examination or the same questions necessarily that you'd ask at a Daubert hearing. They're different inquiries.
Liz, I think your point about the distinction between fact-finding by the judge versus fact-finding by the jurors when it comes to experts, your point that the distinction is somewhat arbitrary, I think is a valid one. I think in theory, at least, your cross is not going to change based on the amendment to this rule. And the theory is, at least, that when you're crossing the expert in front of the jurors, you're making points that go to the weight of the expert's testimony as opposed to the admissibility. The judge already determined it was admissible, and now you're just cross-examining on weight. But I agree, all the things the judge considers and is supposed to consider under 702, the 4 factors, are all legitimate cross points that can and should be made on the issue of weight to be given by the jurors, even if the judge has preliminarily determined under the 104A hearing that the expert's testimony comes in.
Well, and I think it's an interesting question because, 104A talks about whether evidence is admissible and a witness is qualified, but it seems like there could be a 104B relevance that depends on a fact as well. So I think it's going to be interesting to see how the courts handle some of these hearings coming out of the clarification under 702. Do you both agree that it's no longer, if the court says, yep, I'm going to let it come in, it's still fair game to cross-examine on those same points when they go to weight? That
Yeah.
the ruling is not a bar to that?
Absolutely, I agree.
Yeah, certainly. And that's not unusual with lots of evidentiary rules. You have evidence, you claim it shouldn't go in front of the jury because it's not, hearsay, and therefore it's not reliable for a whole variety of reasons. Court allows it in, you're still going to make those same arguments in front of the jury. So that doesn't change.
Let me ask you a slightly different question because we've been talking about Daubert. Does Daubert still apply?
Yeah, so that's a really interesting question. And I think the first answer, or the way people like to think about this, is if you had a Supreme Court case that interpreted a statute, and then that statute was amended 2 times after that opinion, you wouldn't cite that opinion and say that's governing on the new statute. You got a new statute. The language of Rule 702 that was being addressed by Daubert is significantly different. They didn't have any of the subparts. It was a much more cursory rule. So to that extent, Daubert is no longer, and arguably since 2000, has not been the final word on admissibility. And what's interesting, and I think something that lots of folks sort of missed and blew by, is that first part of Daubert opinion itself. They were addressing the question of whether the Frye standard applied, which was a common law standard. And in rejecting that, they made the point, we have federal rules of evidence now. And the federal rules of evidence govern, not case law. And so the court itself was sort of establishing the rule that you need to look at the rule. You can't be looking at cases, particularly cases that predate the rule, as providing the standard. So to a certain extent, Daubert wrote its own epitaph there. I do think Daubert is important in the general, it's still important for the general proposition that courts stand as gatekeepers. And that's what Rule 702, what the gatekeeping requires under Rule 702 has become more structured, but this concept that Rule 702 is looking to judges to be gatekeepers against expert testimony and the reasons why that's so important, I think that's still important precedent.
Eric
What
is
do you-
someone who has studied Daubert and served on the committee, and his point that technically there's an argument to be made, not just an argument, Daubert is at least in significant respects obsolete. I think day in, day out, the roots of Daubert have, really grown in the soil of the law, so to speak. And I cannot imagine judges and others and seeing in motions to strike experts, no reference to Daubert or no discussions of Daubert in hearings. It may happen, but I will have long retired from the law, I predict, when and if it does happen. So I think Daubert is probably here to stay, but technically, if there are parts of Daubert you don't like or that arguably are at odds with the amendments beginning in 2000, as Eric pointed out, then I think it's fair game to say the version, Daubert was decided under a different version of the rules, and this, 702 has now been amended twice, right? I think twice, 2000 and now in 2023. And it's not your father's or your mother's 702 that's being discussed anymore.
You can file a Daubert motion and not look like an idiot, or do you just say challenge to expert under Rule 702?
Now, so the Lawyers for Civil Justice have a new logo on this, which is "Don't Say Daubert," and there's a website you can search which says "Don't Say Daubert," and that's sort of their mantra to get practitioners to think about this in a different way. And it's a nice alliteration. I think it's also, though, important. It's not because courts have gone into the habit. There are cases that rely upon decisions back in the 1980s on expert admissibility, and it's not the way you should be doing it. And the fact that part of the debate within the advisory committee about whether or not to amend the rule was, what are we supposed to do? Amend the rule to say, listen, we meant it. Do what we told you to do in 2000. And that was a significant issue because usually, the rules committee, it writes a rule and it expects courts to follow it. And if the courts don't follow it, there's nothing they can do. The fact that they felt compelled to amend the rule to clarify it, I think, demonstrates the extent of the problem that they saw out there in some of the existing case law.
Well, we always had a fight over whether it was Daubert or Daubert anyway, so maybe this will.
Or Daubert.
Yeah, exactly.
Eric,
Okay.
come to our neck of the woods where we say voir dire.
I've been there, but I don't have the accent. No question.
Yeah. Okay, so let's talk practically about what these challenges look like strategically. What are you going to be arguing for in times of timing? Baylor is all about practice-oriented, practice-ready. So let's spend a few minutes with our experts getting good practice tips, both on the challenges and on responding.
So I'll go back a little bit earlier than that, if I could. I mean, I think Quentin has mentioned this as well. The practice point starts well before the hearing or the brief. I mean, the practice tip is how do you work with your experts to begin with, and what can the expert, and we've seen this has happened sort of anecdotally. There are experts who have sort of pulled back on certain opinions that they recognize they can't offer under the new rule. So the first step is going to be take out Rule 702 as you're working with your expert and figure out if you can actually meet all four of the standards in submitting an expert report. And if you can't, you got to figure out what that means for your case and how you want to present it. But then a lot of the procedural steps we've been talking about, having it baked into the the pretrial order, having sufficient time set aside for the court to deal with this, understanding whether or not you need to have an evidentiary hearing. Those are things you need to be thinking about early on in case management and talking about with the judge early on.
Are you going to write your reports differently? Have your experts write their reports differently?
I think that you're going to need, and you should have already been doing this, quite frankly. Best practices already dictated it, but to the extent there was any doubt or any ambiguity, the amendment to Rule 702 in federal court that may soon seep into Texas court. I think we can talk about that, or state courts in a minute, but you should have been doing this from the beginning when you hired your expert. You should have been determining what they need. If they need deposition testimony or studies or whatever it may be that they need to get from you, you better have caucused with your expert. The idea that you just wind up an expert and say, I need a report in 6 months and don't communicate with them again, I think to the extent those days ever existed, they're gone. So you should be finding out what your expert needs and fortifying your expert with these challenges in mind. Assume that your opponent is going to challenge the expert. Assume you're going to have to show the 4 things in 702 by essentially a preponderance, more probably than not, which is a preponderance, the note says. And then when you're dealing with your opposing experts, I think you should be developing during your cross of the expert in your discovery deposition the challenges so that you can show in a PowerPoint or whatever it may be in the Daubert, however you articulate the word, hearing, 702 hearing to the judge. Here were the questions I asked. I asked questions pointedly directed at, cued on, crafted from the language of 702. I asked the expert exactly about this, and the expert said, I don't know, or there aren't any studies, or whatever it may be, so that the ambiguity is removed. And so all of that starts back early. Don't wait to the last minute, whether you're proffering the expert or contesting the expert, be locked and loaded at an earlier date. You should have already been doing that, but I think the amendments make clear you better darn well be doing it going forward.
You know, it's an interesting thought because I know in certain MDLs and mass tort cases, in IP litigation, it's not uncommon for there to be essentially a science day.
Yep.
Is that something that is now a potential option if everybody thinks, you know, we may be fussing about this, is proposing a science day something that, because one of the things you both talked about is the judicial reluctance, because it is hard. Some of this science is very technical, very difficult. You have well-qualified experts arguing vehemently that the other is an idiot in their application of the science. Is that something to consider? And if not, and let's say busy judges don't have time for a science day, Quentin, I think your idea about PowerPoints or whatever, I mean, how are you visually going to teach some very complex science to a busy district or federal magistrate judge?
Yeah, we've used science days and we've had science days in MDLs. I think in MDLs, the courts are recognizing they've got a significant responsibility and they are open to that. And again, courts, this is now that there is a new Rule 702 and courts see that they've got this obligation and there's judicial training going on. I've been involved in some of that where judges are learning they've got to do this. There may be more interest that courts have in having sort of these types of science days. And a lot of times, though, the science days are not as heavily contested as everything else. I mean, experts ultimately will, the methodologies are what the methodologies are, and you can provide the court a roadmap. Then each side needs to show that their expert satisfies it. But I've had science days where it's not dramatically different presentation of what scientific method means on both sides.
But you raised what I think is the interesting issue. Is this going to trickle down, much as Daubert did, into state courts? What's your thought? Because Eric's point is well taken. It is a rule. It is structured. It's a rule. It's not case. And to the extent state-based 702s don't track, how much trickle-down effect do y'all anticipate?
I I anticipate a distinct possibility. One needs to look no further in Texas than proportionality, which came about, in cases and now in the rule. So I would not be surprised at all if we had changes that were the same or similar to Texas Rule 702 as a result of this new now federal initiative. Usually there's a delayed period, and it seeps sometimes into some of the opinions before the rule itself changes. If the rule is going to change, we may have some opinions that rely upon federal case law that, I think Eric's point is some of the cases in federal court were being decided incorrectly based on a misinterpretation of the rule. Now that the rule leaves less ambiguity, we're going to have cases that skew perhaps more towards a stricter enforcement of the showing of those 4 requirements in 702, and some of the subtleties as to why exactly those federal cases were decided that way, namely based on a federal rule that may not mirror the Texas rule yet, if ever, may be lost upon some of the Texas courts who may, in a knee-jerk reflexive fashion, cite or rely upon a federal citation, a federal opinion in striking an expert, for example.
Yeah, I mean, I think there will be, it's obviously going to be state by state. I think Texas may move more quickly than some other states because Texas has a established Rule 702 precedent. We're already starting to see the language come into some states. It's going to be a period of time. In some states, we have states that still don't apply Daubert. There's not many of them, but there are a few, so it'll vary.
I don't guess you keep a listing of all those federal cases, Eric, that are now no longer good law.
Actually, if someone's interested in that, we are preparing something along those lines. So there is going to be a publication coming out that will have a listing of cases that certainly use language and analyses that are inconsistent with the amendment, and that some of them have been specifically referenced by the advisory committee or referenced in my law review article. So some of them are easier than others, but yes, there's something in the works.
So list of bad law.
Yeah.
Amazingly, as always happens, we have blown through an hour of time. Eric Lasker is at HollingsworthLLP.com. Quentin Brogdon is at Crane Brogdon LLP.
CraneBrogdon.com.
Yeah. So these gentlemen write and speak and are real students of the law and expert practitioners. And guys, it's just been a great pleasure having you on. Join us again next month. We'll be back on the last Wednesday of the month at noon, as we always are. Thanks for your time and have a great day.
Thank you so much. Bye, everyone.
Bye. Thank you. Thank you, Liz.
Thanks, Liz.